Well, there have been a lot of comments from people who suggest that the Supreme Court has taken a position on the great ideological divide over trans rights. But actually, the case is concerned with a difficult question of interpretation of a relatively obscure statute, namely the Equalities Act. And all that the court has decided is that for that particular act, but not necessarily generally, man and woman have their biological meaning. So what does that mean in practice? Well, the Equalities Act makes it illegal to discriminate against trans people, but it allows people to provide certain facilities available to only one sex, such as single-sex toilets, single-sex changing rooms, single-sex schools, single-sex sporting events, and so on. And people who provide those kind of facilities or activities are not to be regarded as discriminating against trans people, simply because they are confined to a single biological sex. The reason why that's important is that many organizations, such as employers, sporting authorities, or public bodies of one sort or another, used to argue that they had to admit trans women to women's facilities and activities because it would be contrary to the Equalities Act to exclude them. And what the court has essentially done is to knock that argument on the head. It's held that in the Equalities Act, sex means biological sex. Therefore, you are allowed to have schools, hostels, sporting competitions and the like, and particular facilities like toilets and changing rooms, which are limited to biological women or biological men for that matter.
Now, that is absolutely clear as you've explained it. You're allowed to have a toilet that is biological women only.
Yes, and that is not discriminating against trans people.
Does that mean women's toilet has to be barred from allowing trans women? Because that's what everyone's taken it to mean, isn't it? You're not allowed to let trans women in, but it's not saying you're allowed to have one that's biological women isn't the same as saying it's got to be biological
That's
women.
absolutely right, and it's the main point which I think has been misunderstood about this judgment. I think it's quite important to note that you are allowed to exclude trans women from these facilities, but you are not obliged to do it. So, for example, the authorities of a sport, such as women's boxing or women's football, are allowed to limit it to biological women. They won't be in breach of the discrimination rules of the Equalities Act. But the judgment doesn't mean that the sporting authorities have got to limit women's boxing or women's football to biological women. They could decide to allow trans women to compete on the same basis as biological women. Some sporting authorities do, although I think that in the light of the latest judgment, they would be wise to say so expressly in their rules.
I want to read you a little paragraph from the Times, because I think I just want to know whether this is wrong then. It says, Baroness Faulkner, who seems to be chief interpreter of this judgment as head of the Equality and Human Rights Commission. So the Times reported, Baroness Faulkner says the landmark judgment had brought clarity and means trans women could no longer take part in women's sport or be on single-sex wards, and that changing rooms, quote, must be based on biological sex.
No, I don't think that's true. I think that the question of changing rooms may give rise to all sorts of other issues. For example, if you have a changing room for women and trans women, which women, biological women, are unwilling to use because they might encounter a trans woman, there might well be an argument about harassment or about failing to provide them with facilities at all. But I don't think Baroness Faulkner is right to say that you can't have trans women in women's sports, simply that if you decide not to have them, you aren't breaking the law.
Right. And I mean, paragraph 2 of the judgment, which nobody seems to have read or mentioned, says it's not the role of the court to adjudicate on the arguments in the public domain on the meaning of gender or sex, nor is it to define the meaning of the word woman, other than when it's used in the Equalities Act 2010. The judgment has a more limited role, which does not involve making policy. They couldn't have said it more clearly there, really, could they?
No,
We're not trying to set the rules here.
I think they've gone to a great deal of trouble to avoid taking sides in the ideological debate, the broader ideological debate. And what they've done is they've gone carefully through the Equalities Act to show that it doesn't make sense except on the footing that where the Equalities Act uses male or female or man or woman, they mean biological men or women, but it's simply for the purposes of that act. Most of the relevant provisions are about the exceptions which provide that it's not discriminatory to provide certain facilities.